When we talk about the judicial creativity, we understand that it is nothing but the power to interpret the provisions of law in a creative manner, not in a stereotype manner. And High Court and Supreme Court, being a constitutional courts, they have much more space, much more rooms with reference to protection of fundamental rights, and by taking assistance whenever required of the international conventions, they can do the creativity while performing the function of interpretation of that particular law. And so the various judgments of the High Courts and Supreme Court with reference to creativity in law, we can identify that because of the judicial process, these courts, they could able to deliver such particular judgments which are actually benefiting to the peoples in India. Justice Cardozo, Justice Cardozo has concluded that there is an element of creation and discovery where the judge can play a creative role in matter of constitutional interpretations. Each case coming before the judge has its own peculiarities, requiring application of fresh mind and skill. So according to Cardozo, judge is like an artist. His work constantly requires thinking and display of talent and creativity. Judge has to provide an interpretation which is consistent with the spirit of that statute or constitution. That is actually the judicial creativity. Judges cannot be a just spectator to the changing times. Rather, they have to be very dynamic in being able to understand the need of time and creates law according to it. So when we see that the constitution is a living document, it has the quality of dynamism, and so it requires to be interpreted in that same manner, for which there is a need of a creative attitude and approach. And so in the judicial process, without creativity, fundamental rights, liberties, life, properties of the citizens, of the people, cannot be protected. Judicial creativity and constitutional provisions, or the interpretation of constitutional provisions, when we understand with reference to interpretation of constitution, court has to always maintain the relevance of the constitution according to the changing social, economic, and political scenarios. The court must adapt a judicially positivist and proactivist liberal approach in constitutional interpretation, because without such particular approach, the correct understanding, correct interpretation of constitution cannot be possible, and the object and reasons what set from the very first page of the constitution, that is a preamble, that cannot be attained. And so while interpreting the provisions of such particular constitutional law, the judges they can balance the practicability and the necessary degree of creativity. And so it is the judiciary who in the democratic setup can play an active role through the medium of judicial interpretations. And this work of interpretation, when we observe from A.K. Gopalan versus State of Madras, in which we understand that the judges, while interpreting the provisions of law with reference to right to life, personal liberty of the person, it is highlighted that how much room, how much scope is there with the courts in terms of fundamental rights and liberties of the citizen. And from that line of A.K. Gopalan versus State of Madras, it is evident that later on, the judgments like Golaknath versus State of Punjab, in which the court has played a very important role, the court has played a very activist role in terms of protection of fundamental rights with reference to power of amendment in Article 368 of the Constitution. This journey of judicial activism, judicial creativity, we can realize specifically In the cases like Keshwananda Bharati versus State of Kerala, this case is popularly known as the fundamental rights case, wherein Supreme Court propounded the doctrine of basic structure, and this basic structure is itself an example of judicial creativity of the Indian Supreme Court, and that demarcate the activist role of the Supreme Court of India with reference to the procedure of amendment in Article 368 of the Constitution and the power of judicial review. What we are understanding as a limitation against the lawmaking power of the legislature or parliament. After Keshwananda Bharati, when we confronted with the decision of emergency of 1975, when the population they were in the need of judicial activism or judicial creativity, in which fundamental rights were suspended, censorship was imposed by the government, and in such situation, ADM Jabalpur versus Shivkant Shukla, one of the very landmark judgment, which is known as a habeas corpus case, in which Supreme Court tried to play a very active judicial role and permitted civil liberties in Part 3 to be suspended during the emergency. Now, this suspension of that particular civil liberties or rather fundamental rights during the period of emergency is somewhat contradictory to the very intent of the framers of the Constitution. But in such particular situation, when civil liberties got crushed, in the democracy, it was rightly felt that judiciary must always be there to guard and protect the liberties of the citizen. And so after that we understand the series of decisions started from Maneka Gandhi versus Union of India. Court widened the ambit of constitutional provisions and held that the provisions of Part 3 should be given widest possible interpretation to expand the reach of fundamental rights. From this judgment, we started to recognize the due process of law in Article 21 of the Constitution. And this particular judgment consider as the a very beginning, it consider as a very mark to enter into the era of judicial creativity, because from this particular point, judiciary, through its creative approach, started to recognize n number of different rights, started to provide various reliefs to the poor, underprivileged, downtrodden sections of the society. From this judgment, Supreme Court could able to put extra strength in Article 21 of the Constitution. From this judgment, life or the meaning of life, interpretation of that particular meaning of life is got expanded, widened. From the misery of life, we recognize life with human dignity. And so, these particular judicial decisions, they impacted the judicial creativity. And so, you people must remember that if you are attempting to write a question of judicial creativity, you have to mention all these particular decisions and how that scope of interpretation, how the expansion of that particular function of interpretation was happen on the part of that particular court. You people have to emphasize on all these points. So Article 21 is got expanded. The room for judicial activism was open for Article 21's right to life and personal liberty. And these fundamental rights, they are not islands in itself. When you are reading Article 21, definitely it would affect Article 14, right to equality. And so, even the expansion of other fundamental rights with reference to right to life and liberty, which also develop the role of judges in the interpretation of the provisions of the Constitution. Now, while performing that creative role, judiciary, they are supposed to take into account the social changes, technical advancement of the society. So they are creatively interpreting, creatively deciding a particular matter, because at one hand there is a enhancement, development of technology, and at other hand the society is lagging behind. Society is not able to cope up with that development, and there is a huge gap between the such particular realization of technological development and the actual conditions of the society. So to bridge that particular gap, judiciary can come forward and they can decide the decisions in a dynamic or creative manner. And that is something what we are understanding as a proactive role of the court in an interpretative process, which guarantees the fundamental rights of the citizen. And from that point of view, we understand gradually the interpretation of Article 21 broadened to a great extent. Initially, when we started from 1950, we understand that Article 21 was a dormant provision. Article 21 was a very stagnant provision that was nearly for 3 decades, we can say. After 1978, in which Maneka Gandhi decisions when actually came, from that particular point, we understand that the expansion of the interpretation of life and liberty, that actually a very precursor for judicial creativity. And so, while protecting life and liberties, constitutional courts always try to apply innovational technique of judicial creativity, and with that technique they try to create new rights and entitlements. And for that reason, if they want to refer international conventions, international law, which are necessary for the protection of equality, for the protection of liberties, fundamental rights of the citizen, they can rightly adapt, they can rightly refer those international conventions, international treaties, international laws. So if there is a matter of protection of labor's right, if there is a matter of protection of women, if there is a matter of protection of children's, and we have witnessed Vishaka versus State of Rajasthan, in which Supreme Court rightly refer Convention on Elimination of All Forms of Discrimination, CEDAW, for protection of working women from sexual harassment at workplace. Article 141 is another tool in which Supreme Court, or the decision of Supreme Court, once it is finally decided, that becomes a law throughout the territory of India. And so that also provides the authority, that also provides the sanctity, that also provides the judges power to play innovative and creative role to ensure the justice. Role of the court in today's era need to be creative, active, rather than the passive. The attitude of the court must be positive. The attitude of the court must be proactive in determining fact and circumstances of each case in today's era. But when we are understanding the strength of the judicial organ, we have to be in that way needs to ascertain such particular strength or power with certain caution also, so that the judicial organ will be more vigilant while exercising its law creative function, and at no point the judicial organ will in an over excessive manner encroach into the field of other organs of the government. There is no doubt that in the journey of judicial interpretation, there is a great contribution of judicial activism, but we have to keep in mind that while placing importance with the judiciary in terms of a democratic setup, in today's era, we need to understand even the judicial restraint also, judicial accountability also, so that we can balance that dynamism, that creativity on the part of the judges in our legal system. Now, in this, we need to understand that judges, while deciding a case, they have to give a reason for their decision. Legal reasoning that plays a very important role. So, reasoning to establish the existing content of the law on a given issue, reasoning from the existing content of the law to the decision which a court should reach in a case involving that issue which comes before it, and reasoning about the decision which a court should reach in a case all things considered. So, reasoning of certain things, they meant as a legal reasoning, and that legal reasoning should apply by each and every court, each and every judge while performing the interpretation or the function of interpretation of that particular law. The very basic that while interpreting the provisions of law, the approach of a judge is of two types: conservative, in that way we can say stereotype, as it is backward looking, and another one that is somewhat forward looking, creative, modern approach. Now these two kinds of approaches itself indicate that in interpreting the law, judges both expecting to capture and be faithful to the content of law as it currently exists. What is the letters of law? What is the very actual meaning of the law? Judges try to catch that particular meaning. Judges try to be a loyal with that particular meaning. And in the existing conditions, they try to adapt that particular meaning from the interpretation of that law. To supplant that particular meaning, or to modify that particular meaning, or to bring out something which is a new in the law in the course of that particular reasoning, or in the interpretation of the provisions while developing that reasoning. This is a process in which we find the creative role of the judge. So at one hand they have the option to be a very rigid stereotype, and at the other hand they have the option to supplement the law, modify the law, to bring out something new in the letters of law. This indicate that because of this dual approach, in the legal reasoning, the ultimate decision what is going to be happen in that particular case, that must attain the satisfaction of issue what frame in that particular case. Whether you think in a conservative manner, or whether you think in a modern, or on the line of development, on the line of creativity, your reasoning should support with the issue what frame in that particular case. You must satisfy the issue involved in that particular case. So it is an intellectual process actually by which judges reach to the conclusion in deciding the cases. Countries like France, Germany, They focuses on codification of law, creating a complex and harmonious body of legal rules and concepts. And on the basis of these codified laws, judges, while applying the reasoning, they could reach to that conclusion. So, reasoning should be seen in a broader sense. So, you frame the law intellectually. Judges, they apply that rules of formal logic to such particular laws. And judges give the reason, grounds for such application of that reasoning. And because of this reasoning of the court, reasoning of the judges, there is a growth in the law. In every case, a judge apply the reasoning, and that ultimately contribute in the development of law, that contribute in the wider interpretation of statutes, that contributes in the significant growth of the law. Change is inevitable. Social transformation and judicial creativity, there is a connection between these two phenomena. In every case, judge are facing a different situation, different circumstances, different cases. There has to be a balance between the change and the stability of the social structure. And with proper legal reasoning and proper growth of law, such balance can be effectively maintained. So, judgment of court, decisions of the court, sometimes we are finding that this is something which is a very contradictory to the social norms, social standards. How court can decide this matter in this manner? But sometimes we need to understand the judges on the line of changing needs, changing circumstances of the society. They came with that particular decision. Always, rule of law is the supreme law, and that rule of law must be followed. That is the significance of legal stability. And society always require stability also. Without stability, there will be a chaotic situation, chaos will be there. And so, stability of the rule of law can be carried by the rule of precedent. So the thing should not be happen in a manner that today's decision of Supreme Court again overruled in tomorrow's case. And so once decided a case by the Supreme Court, that brings out a stability in the society. So basic structure doctrine evolved before 50 years. But even today also, doctrine of basic structure is firmly holding its position. That is the stability of rule of law. Because we are accepting under Article 141 that once it is decided by the Supreme Court, it is itself a law. And law cannot be changed again and again. Law gives a certainty. Law gives firmness. Law gives somewhat a very stability in that particular system. And so from last 50 years we understand that basic structure we are accepting as a law, and every court throughout the territory of India is following the mandate of Keshwananda Bharati versus State of Kerala. If precedents are not useful to the society, or if precedents they are not useful in the making of the judgment, in interpreting that particular decisions or the provisions of law, then the judges have to refer some alternative ways of judgment making. And so in such particular case, judges they are not bound by the rule of precedent. They are very free to use their own wisdom and intellect to create a new law. And that is actually what we are understanding as a judicial creativity, whereby judges, instead of playing a passive role, plays an active role in lawmaking. And so, with reference to this particular discussion, we understand that stable rules, stable legal rules, though ensures predictability, certainty, but whenever there is a change, whenever there is a need of a change, by way of a judicial creativity, it can be guaranteed to ensure the justice in the democratic setup. So judicial precedents, whenever required to be altered, then that alteration, that modification can be possible in a retrospective or prospective manner through judicial creativity. That is the very importance of this particular judicial creativity or concept of judicial creativity. So these are the things that you must remember to understand the concept of judicial creativity.